Hello, everyone. We are doing a session today on the criminal justice system in the UK. And today, our guest is Mr. Malik Siddique, and he is a senior solicitor advocate in the UK. And he's going to start with his introduction, and then he's going to take us through some of the interesting aspects of the criminal justice system. And if you have any questions, you can ask the questions in the comment section. And we can share your question with Mr. Malik, and he can provide his insight on that. Welcome to the show, Mr. Malik. What would you like to tell our audience today?
Firstly, Mr. Mahmood, thank you for inviting me onto the show, and thank you to the audience who are going to participate, hopefully, in this interesting subject this evening. So, good evening, ladies and gentlemen. Assalamu alaikum from me. As Mr. Mahmood has already explained, my name is Malik Siddique. I was born, raised, and educated in England. My parents hail from Pakistan. I'm a lawyer by profession. My full title is I'm a solicitor advocate. Some of you, I'm sure, will already know that in the legal profession in England, there are two professions. There is the solicitor's profession, and then there is the barrister's profession. Some years ago, I think 15, 20 years ago, the Law Society and the Bar Council got together and said, look, solicitors should have rights to be able to conduct cases and hearings in the higher courts, for instance, High Court, Crown Court, etc., both in criminal proceedings and in civil proceedings. And this would be for those advocates who were very seasoned, who had at least 5, 6 years, 10 years qualifications as a solicitor behind them, especially in criminal proceedings. So, to cut a long story short, that legislation came into place, and initially it was based on your experience, and your local district judge would give you a reference to say, Mr. Siddique is okay, yes, he's done so many trials, etc. I think he's okay to go on to do higher courts work. By the time I came around to it in 2007, I think it was, I had to take an exam. So I had to take a course, and then I had to do an exam to prove myself. And I then became what's known as a higher courts advocate. So I am a solicitor and like a barrister as well. In other words, I have the same rights as a barrister. I can appear before any court in England and Wales just like a barrister does. So I have the beauty of being get one and get one free. So I'm both. Basically, that's what a solicitor advocate is.
So I've seen from your profile that basically you have a practice in the area of criminal law primarily, right?
Yeah.
Okay.
I started my practice, you could say my father, my dear father, bless him, put me in touch with a solicitor friend of his when I was about 8, 9 years old in England. He used to buy properties, etc. And said, look, I'd like my son to work with you during his summer holidays. And basically I worked in his office doing all sorts of things, post and so forth, usual clerk in an office. And he had some files archived upstairs in his attic, and I went up to his attic one day and opened up his archive and started reading some very interesting files regarding children who were born out of wedlock in England in the 1950s, 40s, etc. And that was almost a sin in England in those days. People were very conservative. If a woman had a child out of wedlock, it was frowned upon, legal the child was taken away and so forth. And I found this very interesting. At the same time, I found it very disturbing. Why is this happening? Surely the mother has a right, child and so forth. And I questioned the senior lawyer, and he said, oh yes, Malik, this was what the legislation was, this is what would happen. We had a very conservative. And that instilled in me a sense of justice. And, I must grow up and really speak for the voiceless, for the underdeprived and so forth. I then went to school, etc. I spent some time initially within the West Yorkshire Police Force as a special constable, as a police officer for 2 years almost. I almost ended up applying to join the Royal Hong Kong Constabulary, but I didn't get.
You started as a police officer.
Hmm.
So how was your experience as a police officer when you started your career?
It was fun and games. I remember from my training, one of the inspectors saying, look, there is no difference between you as a constable and the chief constable. And we said, in what way? And he said, well, you have the same power of arrest, both of you. It doesn't matter what your rank is. For a police officer, the power of arrest is a very, very powerful tool. You know, when you have to make a judgment, you have to arrest somebody, you're looking at potentially somebody's innocence or guilt. You're looking at the rule of law. You're looking at whether the evidence that you've collated is fair, etc., whether it will stand up in court or not. But that mere power of arrest is a very powerful tool because, I say this for this reason, every criminal case starts with an arrest or an investigation by the police. That's the beginning. That case is conducted under interview in a police station. When a suspect is taken to the police station, the first right he has in England is he can ask for a lawyer to represent him. He can say, I want Mr. Siddique because I have a company, he knows me, and he's used me before. Or he can say, I don't have a solicitor. Then the police have to give him a duty solicitor. And what a duty solicitor is, he or she is available 24 hours of the day or night, 7 days a week, 365 days of the year. And they are known as duty solicitors because we have to go through a special interview, etc. They are practicing lawyers who have been practicing for many years, and they are allowed to do serious cases and so forth. And that suspect then will say, yes, I want a duty solicitor. So immediately, even before a police officer can question him, he has a right to speak by telephone with a solicitor. Then when the police are ready for an interview, they will call the solicitor and say, would you please come down? A client at the police station has certain rights. He has a right to get a lawyer. He has a right for someone else to be informed of his arrest, unless it's a very serious crime and the police have put a block on all calls. He has a right to medical treatment, etc. He has a right to the codes of conduct, the police and criminal evidence conduct book, so he knows what his rights are. The police have to give him that. He also has a right, if he's a young juvenile under 16, he has a right to have a social worker there, and his welfare must have to be looked after. He also has a right to sleep, to food, rest, and so forth. So the police cannot do anything until those rights are here, because if they don't, then that can become part of the trial process, the case can collapse. So then we go along to the police station, we find out from the police what evidence they have. Sometimes they give us the evidence, sometimes they hold the evidence back a little bit. Based on that, we then as lawyers have to decide how we will advise our client. To say, look, I think the police have got a very weak case here. They've got nothing here on you at all. What's your situation? Now, the client will have three instructions. Either he will say, look, I'm guilty, I've done something wrong, they've got me, the evidence is there. That's easy. We tell the police, hopefully he'll get full maximum credit for that. Or he will say, no, I'm not involved, I've done nothing wrong at all. We then have to decide, should the client answer the police questions? Or at this stage, should he say nothing? Because sometimes the police don't have all the evidence. Sometimes they have to see other witnesses, etc. So we might say to the client, look, we think at this stage you should say nothing. Let the police get the evidence and we'll interview you.
Sorry to interrupt. I think your voice becomes clearer when you're closer to the computer.
Right. Sorry. Can you hear me now?
Yeah. So so there was a little bit of echo. So you started as a police officer, and you wanted to work in the justice system.
I wanted to go into full-time policing, but then I decided to go and do my LLB law degree in England. So I decided to go along and do the LLB law degree. When I finished my law degree, I had to do my 2 years training as a solicitor with a practice. I did my training with them, and then I became a fully qualified lawyer within a solicitor's practice. I trained in civil work, criminal, which was natural to me, family law, and also in immigration. But in the end, when I qualified, I decided to become a criminal lawyer and to defend, not to prosecute, but to defend criminals.
Okay. So why did you make that choice?
I think that was primarily, I found it more challenging to be able to defend rather than prosecute, because the police collate the evidence, they charge a client, you have to look at that evidence, etc. You have to decide, is there sufficient evidence there for them to take it to trial? If they are going to take it to trial, Are they going to be able to prove their case? It's a bigger challenge. And also, sometimes they do make wrongful arrests. Sometimes innocent people do get arrested. And again, it was for me to make sure, to ensure that the rule of law is applied, that the defendant has a fair trial, and that everything has been followed by the letter of the law, and to be his voice in court.
So there is this term, presumption of innocence, and
Yes.
so I think it kind of relates to what you are talking about. He has the right to a lawyer. So can you tell us more that how uh, this theoretical term is practiced in the criminal justice system in the UK?
Yes. Yes. Presumption of innocence is that the prosecution, the state in England, the state prosecutes. It's the Crown Prosecution Service. The police investigate, they gather all the evidence together, they will then decide should we prosecute in the lower cases. If it's a serious case, they will then send the file to a prosecutor. He will then look at it at the prosecution stage and say, I need X, Y, Z, or yes, this should proceed to trial now. But the presumption of innocence is, and it's the case of Wilmington, which was established many, many centuries ago in England, where the state has to prove the guilt of the defendant. The defendant does not have to prove anything. He does not have to prove his innocence. It is the state who has to prove his guilt. The presumption of innocence is that if there is reasonable doubt in the case, then a verdict of not guilty should be returned. And also in the caution that the police give to the person when he's arrested, a police interview, is that you do not have to say anything, but it may harm your defense if you fail to mention anything now that you may later rely on in court. But whatever you do say may be given in evidence. Now, I'll break that down into three basic points. Firstly, immediately the law is giving you the right to say nothing to the police. You don't have to say anything to them.
So like, sorry. On this first point, like in the US, we have this the Fifth Amendment right, not to share information, or that may put you at harm's way with the police or with the justice system. So in the UK, there is this similar. The first right is that the person who is being arrested, he doesn't have to say anything.
Yeah, it's contained within the Police and Criminal Evidence Act, which is the procedure for how the police investigate the rights of suspects, etc. And the caution is very important, because if that caution isn't administered at the beginning of it, and I've had these incidents. I once had an interview very early on when I was a trainee solicitor. The police officer forgot to give the caution at the beginning of the interview.
Okay.
So I didn't say anything, just sat there quietly. Quickly, he forgot. It was early hours of the morning. It was 2 or 3 o'clock in the morning. He forgot. We took it to court. We had the case thrown out because the police forgot to give the order. And so whatever the client had said in the interview couldn't hold any water, because the law said you never cautioned him, you never warned him. So that's the first part. And secondly, it is saying to you now that if you don't say something now, but later on you say it in court, the court might think, why didn't you say that at the time at the police station? But that's another complex topic. That comes down to evidence. There may be reasons for that, because I, as the lawyer, may advise the client to say, I don't want you to say anything at the moment, because there are legal reasons for that. It doesn't necessarily mean that we've just made this defense up once we've got to court. The last part is very, very important, because whatever then the client says in the interview, it's recorded. That then can be used against him in court. So if he admits it all after the caution, that is evidence against him. Does that make it easier?
Yeah, I think so. So these are all the rights. I'm just thinking and comparing with the Pakistan criminal justice system, that here we don't have this tradition of telling the arrestee that he has the right to a lawyer, and then he has the right not to say anything. And so I'm assuming then the police cannot put the arrestee in the UK in a position that is difficult, or that can be considered harmful. I'm not saying torture, but like in the movies we see that the police, they intimidate the arrestee and they put them they try to threaten them and they try to get information out of them. So does that happen in practice in the UK, or does that not happen?
Sometimes the police can be intimidated. They might say to a client, look, you don't need a lawyer, you don't need him. It's going to take time. Look, this is only going to take 10 minutes. Let's have a quick. Some people are vulnerable. It may be because they're on drugs. It may be because they are mentally incapable of making that judgment, and they might think, okay, we'll just get on with it. Police officers may ask them leading questions in the interview. They may say, we have got X, Y, and Z, when they haven't got that evidence, etc. They may have frightened him. So at that stage, he'll go along into the afterwards. He may come to us and say, "Look, at the time I asked for the doctor. They didn't give me a doctor. I wasn't feeling well. I was on medication, or they threatened me. They said they were going to arrest my girlfriend as well, or they were going to arrest my son. I didn't want my son or daughter being arrested, so I just said it to them at the time." That's known as confession. That can have technicalities where you can have confessions thrown out where the police have not adhered to the Police and Criminal Evidence Act. They haven't adhered to the codes of practice, and it does happen. And we have had many cases thrown out.
Okay. So I think a lot of this, the criminal justice system is governed by the Criminal Evidence Act.
It's by statute. Parliament passes statute, then obviously it's enacted by Parliament, and then the courts look at that, and they will take this conduct and the codes of practice as part of the trial. It's the whole process. So every case at the police station, they have to get it right, and then it goes to court, and then they will charge that person with the offence. Every case starts its life at the Magistrates Court. That is the first court in the criminal proceedings. Some cases, which are summary cases, that means they will only be dealt with in the Magistrates Court. So the client will appear, either he will plead guilty, and they may deal with it straight then and there. If it's the first time, they may give him a fine, a community order, not send him to prison, goodbye. Some may say, no, we're pleading not guilty, then a trial date will be set. Then he'll come back a few weeks later, a few months later, we'll have a trial. At the end of the trial, either that person will be found guilty or not guilty.
Okay.
Some cases, they may get thrown out. We might say, look, the police have abused the powers of court, the powers have been abused. We may make a half-time submission during trial and say, look, the prosecution have not been able to prove their case, and we think this case should be kicked out. And the judges, the magistrates sat there, will look at that, we'll make our legal argument. They may come back and say, yes, Mr. Siddique, we agree with you, we are stopping this trial. They may say, no, Mr. Siddique, we think we'd like to hear your evidence as well, and then we'll make a decision. Then there are other cases which are more serious that come to the Magistrates Court, but the Magistrates Court does not have the powers to deal with that case. That case will be sent to the Crown Court.
So I have a question about the Magistrate Court. So does the Magistrate Court has a jury, or does it not, or is it just a judge and the person who has been arrested and the lawyers?
Yeah. In the Magistrate Court, the primary people you have is the defense lawyer,
okay,
and the prosecution lawyer. Then you have 3 magistrates sat on the bench. They are lay magistrates. They are not legally qualified. They are appointed by the Lord Chancellor's office, by the government. They are people who are within the community. They may be businessmen, they may be lecturers, academics, they may be shopkeepers, they may be doctors, they may be nurses, as long as they're not related to the legal profession. Now, they get some training, and then they are advised by the legal clerk, who is a qualified person, who will advise them on the law, etc. So they are the arbiters of law, fact, and they also of the verdict. They make the decision. Yeah.
So what you're telling me, that in the Magistrate Court, the judges are not trained in the legal profession, but the clerk is.
Yes, the clerk
and the clerk is there to guide them, and the judges are. It's kind of like a small jury, like a jury of 3 people who are magistrates, and they are acting as magistrates,
in
right?
Trial, the jury as well. You could say that if you want to use that analogy, then yes, you're correct. But sometimes in the bigger places, you do have a magistrate, a stipendiary, he's known as. He is a qualified lawyer. He's a part-time judge, or he could be a full-time judge, and he's sat as a single judge. But that's the big problem. In the bigger cities, you have, so he gets. The cases move a lot faster. But normally, traditionally, you have 2 or 3 lay bench magistrates.
Okay.
And then you have the police, obviously, in there, you have the court usher, you will have the social services there, you will have the probation services there who prepare reports on clients to advise them what sentence, what their background is, how they feel about the offence, etc., whether they have any medical issues or not.
Okay. So that is the magistrate court. So, but you are. So, what about the Crown Court? How is the Crown Court different, and why is it called the Crown Court?
It's called the Crown Court because that's where the much more serious cases are. So they used to be called the assizes at one time, and that was abolished. And then there was a magistrate in the Crown Court. Then you have the High Court. Then you have the Court of Appeal, and then we have the Ultimate Court, which used to be called the House of Lords, but it's now the Supreme Court of England and Wales, and that's where the final appeals on law, just on law, appeals on conviction and sentence go to the Court of Appeal. So the Crown Court, you have a single qualified judge, and that's where all the serious cases like murder, rape, in murder cases, much more serious cases, you have a High Court judge who sits in the Crown Court. In the Crown Court, you have what are known as the recorders. They are part-time judges, or they are part-time judges and recorders. Full-time judges are Crown Court judges, and they hear jury trials. So they will have a panel of 12 jury people. Again, they are elected by electoral register. We have an electoral register in England, and they are appointed by the local council. They will pick out people, and they will call them jury service. It's a civic duty. So people have to go unless they have a very good excuse. And there, if you plead not guilty, you will have a jury before a panel of 12 people. And the judge then again you'll have a prosecutor and you will have a defense lawyer. And the judge will be the sole arbiter of the law. He will make sure that both sides are playing by the rules. They are adhering to the evidence of the rules of evidence, etc. They are not asking questions that they should not ask, etc. But he is not the arbitrator of fact. It will be the jury that will decide the verdict on the facts and the evidence that they have heard. The judge has nothing to do with that. He will sum up after a jury trial. He will say, look, members of the jury, this is what the prosecution have said. You have heard the witnesses, what they said. You have heard the defense. You have heard the defendant, if he's given evidence, etc. Members of the jury, it's time for you to now retire and make your decision on what you think. And if the jury have a question, they can come back, they can ask the judge, he can guide them, but he does not make the decision. What goes on in the jury room, we even as lawyers never know. They're under lock and key. They are not allowed to discuss the case with anybody whilst they are sitting, whilst they are deliberating, etc. And the jury has no contact with the lawyers at all. When the jury is being sworn in, we are sat there. Sometimes I've known a member of the jury and I've said to the judge, I know this, or that person might say, we know Mr. Siddique. And then choose somebody else if there's a good reason.
So, if I would have to ask you that, what are some of the challenges the criminal justice system as a whole is facing in the UK? So, like we have seen in the US, we have this huge challenge of prosecution of African Americans and drug charges, and they have these huge prison incarceration system where they have prisoned a lot of people, thousands of people, hundreds and thousands of people. So, are there any similar issues or patterns that you can see in the criminal justice system in the UK while you have worked there in that system?
One of the biggest challenges we have in the criminal justice system at the moment is funding of a case. In England, we have a legal aid system where the government pays for the whole defense case. People can get legal aid, they don't have to pay a lawyer at all.
Okay.
That over the last 10 years has been eroded. There have been a lot of cutbacks. So a lot of shortcuts have been made. And when you start making shortcuts, there's a lot of pressure upon lawyers in preparing cases, etc., because they're not getting paid what they used to get paid before. They have staff, they have overheads, etc., and so forth. Now, I'm not suggesting that lawyers are taking shortcuts, But clearly, even on the prosecution side, because of government cuts, etc., sometimes cases are not fully prepared, things are missed, etc. And there is aptitude, there's always a chance that there may be miscarriages of justice. Evidence that should have been disclosed may not have been disclosed. Now, I'm not suggesting the police or the prosecution have necessarily played bad boy. Sometimes they do. Later on, it comes to transpire. It may be because of lack of funding, etc., they've missed it.
Okay.
And it may transpire later on. So there can be miscarriages of justice. Sometimes, yes, there may be certain officers, there may be prosecutors who may be biased. We never know. But we have a system whereby, luckily in England, we are able to challenge any and every piece of evidence. So we have everything in our favor. So if we think some evidence is suspect, we have a right to say to the judge or the court, we want more disclosure. We challenge this particular piece of evidence. There are rules on how the evidence will be presented, whether that evidence is fair in the prosecution or not, whether it is detrimental. The defendant has certain rights. He has a right to a fair trial. So that's enshrined under Article 6 of the Human Rights Act that we have. A client will have a fair trial. He has a right to a fair trial. So we're allowed to challenge, and that is our safeguard.
Okay. So we have this question from Hamza Shakil Qadri, one of the audience member. And so I'm going to answer his question in the Pakistani perspective, and then I'll let you answer his question from a UK perspective. So he's asking what is the best way for a mature student? I think he means like final year students to see criminal or any work experience, especially if they belong to a non-law background. So if your father, so Hamza, if your father or your family members do not belong to the legal fraternity, and you are about to finish your LLB degree and you're looking for some experience, you can always contact your law college. So like at Blackstone, we have this tradition of law clinic where we teach students, we pair them up with barristers and senior lawyers, and we call it law clinic, and they work on real cases in their last year of degree. But if your college does not provide that opportunity, what you can do is you can always reach out to law firms, and law firms are always looking for people who are hard work. There's this job of a paralegal. It's not stated paralegal in Pakistan. There is no such category, but basically your job will be to do research on case law, because any lawyer, they have to do a lot of case law research. So if you develop some skills in the case law area, so you can assist any criminal lawyer and help them do their research. And so that is one way you can find work. If I have to ask the same question, and if there is a student in the UK, and let's say they are doing their BPTC, or they are in their final year of LLB, and they're looking for an opportunity to establish a practice in criminal law, what should be their starting point?
Hamza, thank you very much for your question. It's an important question, and it's a good question, because all law students, wherever they are in the world, always want to know how can we get practical experience. And I think to a certain extent, Mahmood, you've answered that question. It's similar in England. What students are told, because in England at the universities you have careers, officers, advisors, etc. Some of the universities are linked with the local legal profession, etc., and so forth. The best way is, I would say, is for you to send your CV, write in to law practices, etc., to say, look, I'm a student doing my first year, second year, third year student, etc. I would like to gain some experience at the office. Voluntarily, I'm prepared to come in. Can you please give me a 2-week mini pupillage or a mini training session? I'm prepared to come in and give my time. And law practices do take on students from colleges and universities over the summer when they're on vacation. That's one way of doing it. You can approach the local prosecution service, the Crown Prosecution Service, and write to them and say, look, I'd like to have a summer vacation placement with you. You could approach the local police station there and say, look, we'd like to come in and sit and shadow police officers. You could write to the local magistrates court, even the local Crown Court. I have seen students shadowing judges and shadowing principals. I have had, when I had my practice in England, I used to take on from schools and universities children during their Christmas holidays, Easter holidays, summer holidays. They'd come and work with me, they'd follow me. So if I went to the police station, I'd have to get permission first, obviously. In court, they'd come with me. When I interviewed clients, if I had the client's consent, they would sit with me. So that's the best way of building that. And then you can put that on your CV with a particular firm. You were with them on placement for 2 weeks, etc. That's one of the best ways of doing that.
Okay. So I have a unique question. So it's from Mia Ali Zaib Baksh. So he's asking that since we are in a pandemic, and while we are going through this pandemic and we are confined to our homes, so what are your suggestions for law students? How can they learn about law or get experience experience of criminal law or any other field of law while they are quarantined or staying at home?
Thank you. Is it Mia Ali Zaid? Mia Ali Zaid. Thank you for that question. I think with the pandemic, what I've realized now is that since March, a lot of focus has now turned to media. Obviously, everything is over the internet now. But there is so much available on the internet. There's YouTube, there's Google, which has been there for many, many, many years. If you are law students, best thing I can suggest to you is obviously read your material that's been provided to you, because you must have your books, etc. and so forth there. Read them, try and understand, do past papers, prepare for your exams and so forth, etc. Look, and I think there are leading lawyers even in England as well that are giving online tuitions. They are also giving online insights into the legal profession. For instance, I know there's a lot of barristers I've seen on YouTube, on LinkedIn, that are actually tutoring young pupils of how to get through or giving them guidance rather, of how to tackle their application stage, etc., what's required in terms of skills and so forth. Please, please, please work on your CVs. Your CV is the most important selling point. Make sure your CV is 2 pages and no more than that. My CV, I remember, was about 5 pages when I first did one. It's very difficult, it's not easy. Try to keep your CV to the basics. Make sure there's no spelling mistakes on that CV, because the last thing a prospective employer or an interviewee wants to see is a shoddy or a CV with spelling mistakes and so on. Please make it professional. And there's many online tuitions for CVs and so forth. So please get your CV right. Do give your interests, even if you feel, well, I don't think it's anything to do with the law. It has everything to do with the law, because it shows that you are a diverse person. So if you've worked in the supermarket and you've been a cashier or you've been in a supervisory role, that explains to me as a prospective employer, hang on, this person has people skills. He's actually been in a position where he has interacted with other people. He's been in a position of responsibility, so he's not just a fresh law graduate. He has other experience and so forth. If you voluntarily help with the local mosque or you do something in your community, even if it's just, cleaning up for elderly people, mention that. Let them know that you have a human side as well. We as lawyers are human beings as well. Something that you're passionate about, mention it, list it. Don't think, my God, it has to be everything law related. No, it doesn't. It is very difficult, but the one thing that you have, which is the most valuable for you as students right now, at this moment in time, is time itself. Utilize that time. Research on Google, research on platforms like LinkedIn, etc. Make links with barristers and other lawyers and so forth, and you will find 9 times out of 10, they will be helpful. They will get back to you. It may take some time because some of them are busy practitioners. Whilst we have this lockdown, people are doing online advocacy, they are having meetings and so forth, and conducting things online. So that would be my advice.
I also want to add a few things to Mia Alize Baksh. So we are having two sessions, live sessions tomorrow. We are going to have one session with a criminal lawyer here in Pakistan, a defense lawyer, and he'll be sharing his insights about the practice of criminal law in Pakistan and how do you go about preserving evidence and how do you go about presenting that evidence to the court. And he teaches at Punjab University. Mohsin Sheikh is the advocate. He's an advocate of High Court here. And then we also have another pupil barrister joining us from the UK, and Aqsa Hussain, and she'll be talking about her experience, how she developed, how she got a pupillage in the UK. So the idea is, since we are also confined at home, we want to make the use of our time, and we want to find people who can provide you insights on how to become a better lawyer. So, like Mr. Malik was saying, that the best thing that you can do is create value in your self by creating a resume that shows not only your expertise as a lawyer or your degrees, but also what you do in the community. Whatever you आप कोई भी काम करते हैं, whatever work you do, make use of that work and put it on your resume so people can look at it. So coming back to the topic, I would want to ask. So, what was the most challenging part working as a defense criminal lawyer?
Oh, people. Because I have
People.
represented
Okay.
people of all faiths, backgrounds, cultures, traditions, professional criminals, you could say, who've been in the system for a long, long time, who are truly know what they're doing. I think the most challenging cases are probably where people who are mentally challenged, when you defend them, what their rights are and so forth. And also from situations where you have mainly sexual offences, especially of children. Many people said to me, whose side are you on? I said, well, look, I'm on the side of justice. I'm a lawyer, I am the defense lawyer. All I have to do is present and challenge the evidence. Then it's up to the prosecutor to prove their case. Ultimately, I as a lawyer don't make the decision. It's not my job to say whether my client is guilty or is innocent. That's for the jury or the magistrates to decide. I don't have a role in that. All my role is to see what the prosecution presented, to see where their weaknesses are, etc. If they can't prove them, to challenge that evidence. And then the client should be deemed not guilty. Sexual offences have always been a challenge, especially where children are involved. I have children of my own, now they're grown up, I have grandchildren, etc. That is a challenge when you're faced with that, but then at the end of the day, you have to stay professional. You have to distance any emotions that you may have, not because I'm an animal or I'm a human being. I have to put them to one side. I have to look at a case solely as a professional. I have to look at the evidence and think, right, on this evidence, can the prosecution prove their case? If this goes to a jury, is he going to get found guilty or is he going to be not guilty? You have to approach it with a professional light. And there's many challenges. Sometimes clients can be very, very awkward where you know the client, especially when you have a client who you are advising and saying, look, the evidence here is against you. My advice to you would be to plead guilty. You will get the maximum credit. If you go to trial and you are found guilty, you're going to get a much more lengthier sentence. The judge is going to have no sympathy with you. So my advice, and they won't, because some of them are stubborn, they say, no, we want you to fight the case. I have to. It's my duty then, and so forth. I should warn the client and so forth. But there are those challenges, and then the difficulty is where sometimes you know a client is innocent. You've had a case, you've done it because everything is evidence-based. Sometimes a decision can go the other way. The person is found guilty, then we have to look at appeal, what may have gone wrong, etc. But 9 times out of 10, if the system works properly, there are safeguards. But I think every time you pick up a case is challenging because you may have a tough bench, You may have a very tough judge. You may have a prosecutor who's not prepared to move. You may have difficult police officers you're dealing with. So within the system, there's people of all sorts, and every day it is a challenge. But having said that, it's a privilege and an honor for me to have served in the criminal justice system. I've loved what I've done. I've met some lovely people around me. I've learned a lot from clients as well. And I'm their voice at the end of the day. I am there to speak on their behalf and make sure that their rights are preserved.
So I think it goes back to what you were telling us about the presumption of innocence. So even as a defense lawyer, if you have a person who is very despicable, who you despise, who has done horrible things as a person, but for your job as a lawyer, as a defense lawyer, is to present that side of the story. So the prosecution present the other side, and I always look at it as when both the sides are presented, we all assume or we all think that we know what is true and what is false, but it's often not that the case, because humans are complex, situations are complex, and the law can itself be very complex. So when both the sides are presented and they're rubbed against each other, and out of that comes the truth, or the closer we can be to the truth, because the event has already happened, and the time has already passed, and there might be evidence, there might not be evidence. When you were talking about evidence, I was thinking about the most recent this discovery of DNA evidence. So we have seen that it has changed. There has been a lot of acquittals in the US when they have used the DNA evidence after so many years, and they have found the person to be of innocence. And again, like you said, there should be no miscarriage of justice. So how is DNA evidence treated in the criminal justice system in the UK?
Very highly regarded, very crucial.
Very crucial.
Very crucial to the investigations. That has changed the whole field of criminal justice, because once scientific evidence, DNA evidence is almost conclusive.
Wow.
9 times out of 10, you can challenge DNA evidence, but 9 times out of 10 now, DNA evidence is almost concrete. It's scientifically based at the room for, unless it's been contaminated in some way, etc., it's conclusive. And a lot of, as you say, 20 years later in some cases, because of DNA, people who had been locked up, accused of rape, of other serious offences, etc., that denied it, but were found guilty, and DNA has come out, and the police have been able to then match that DNA, sometimes by accident, purely because they've arrested somebody else for some other unrelated matter 20 years later, and they obviously checked that DNA, and it's come back. My God, this matches with an offence that took 20 years ago, and it's my God, we got the wrong person. See what it's opened the doors to something completely different. You know, your fingerprints are unique. I remember ear print. The first time I went to the police station, now your ear. People who, for instance, burglaries. You know, they broke the window, they went into the house, etc. Lots of officers, what's the evidence? Oh, we've got DNA evidence. What DNA evidence? Oh, well, your client's ear print. Ear print? What's this? You know, and it's conclusive. It's conclusive. Fingerprint, your thumb. Those there have to be certain characteristics. I think if it's more than 16 characteristics, more than that, it's conclusive. If it's less than that, you can argue. So science plays a very great part in the investigating process. I think it's made it a lot easier for the police to be able to cell site evidence. In drug cases, the police now use cell site evidence, where your mobile phone can more or less place you around the location of a crime. It may not be concrete, but it will give an exact sort of, almost near enough exact time, what day, where you were. And, you know, trying to explain that at a trial, the jury will want to think, yeah, he might have been somewhere by accident once, but this is like a dot. You know, the prosecution can build a case up, and your client's going to have to explain that. But sometimes, also, that cell site evidence could help the defense, because the client might say, no, hang on, I wasn't there. Somebody's given a false statement or they got it wrong. It wasn't me who was there. I was somewhere else, and we could say, right, okay, we're going to get your mobile cell site evidence to prove that you were nowhere near the location. So it can work both ways. It can
Okay.
work both ways.
So we have another question from Mia Ali Baksh again, and
Sorry?
his question is, how much credible is video evidence?
How credible is video evidence?
Yes.
Firstly, it has to be of good quality.
Okay.
So it would have to be of very good high quality. Now, there are two types of video evidence. There would be video evidence just showing visually what has gone on. Okay? No verbal talk. Then there may be something which is just audio evidence. So you'd have to prove in England, we'd have to prove that the voice is of the person the prosecution alleged it is.
Okay.
On visual, obviously, we would have to see what exactly that. I'll give you an example. For instance, a real case that I dealt with. I had a young Iranian, I think he was Iranian, or was he? I can't remember, Iraqi or Iranian gentleman. He goes into a garage with his 9-year-old child to get his car fixed. He's then seen walking into the main workshop, and he's bending over and he is talking to the mechanic. And all of a sudden, he starts punching. My client starts punching the mechanic. So this is all on video. He's guilty because he started punching the guy. So when I saw him, I said, "Look, you're guilty. It's on video." He said, "Yes, Mr. Siddique, I know I'm guilty, but please listen to me. What happened?" He goes, "I went there, and I said to the guy, look, I was talking to him, and he said, this guy, the mechanic, he's a Muslim as well. He turned around and he started swearing to me, and he gave me a mother effing. And he goes, in Islam, I'm a Muslim, my mother, I believe that heaven is under her feet." When he said that, I said, "Look, you can call me Iraqi, whatever you want, anything, but don't swear." And he said it again, because I lost control, and that's why I started punching him. I said, "Okay, that's fine." So when I went to court, I made them play the video. And I said, "Yes, my client is guilty, no doubt about it at all. It's shameful because his son was there at the time. He shouldn't have done that." I said, "This is the reason." And the prosecutor said, "No, you can't use that." I said, "No, I can use it because it's part of mitigation. He was provoked." I said, "Look, when the mechanic swore to him about his mother, his faith as a Muslim is that my mother under her feet is heaven." And I gave him some quote from Imam somebody, and the magistrate said, "Thank you very much, Mr. Siddique." They fined him. They didn't send him to prison. So you see how you can use certain things in your favor. There was no audio, but the court believed him. They said, "Yes, Mr. Siddique," because as a lawyer, when I speak in court, the magistrates and the judges think I'm an officer of the court. As long as I don't mislead the court, because if that happens, that's the end of my career. We don't do that. We have to believe what our client tells us. Now, if he's lying to us, we never know. We have to take it. They are his instructions. If he's found guilty because he's lied, then that's his problem. We as the lawyers have to play according to the rules of the law, the rules of evidence.
I think ethics is a big part of the whole UK legal system, because the students who do the bar transfer course here with us in Pakistan, they get all their English law courses exempted because they have experience here in Pakistan is a common law jurisdiction, but they don't exempt ethics. They don't exempt criminal litigation, civil litigation, and advocacy. So they still have to sit for exams for those 4 subjects. And I think, and I always used to think why ethics is a big part. And like you said, the whole system is based on the trust that the solicitor, the barrister, the lawyer, advocate, they are telling the truth, and they are not, and they are basing it on what was told to them by the client, and they're not adding or removing anything from that. So that is why the truth can come out. So we have another question. What about admissibility of a video as an evidence if the video was recorded without consent?
Ujala, thank you for that question. I don't know whether he's asking me that from a point of view of law in Pakistan or law generally in England. Sorry, I'm not sure what the question is from which point of view it is, but as I said, video evidence is evidence because it could be from CCTV camera, etc. That's obviously available to a criminal, to a police officer during an investigation. So far as where a video may be recorded without the consent
of the person who was who recorded.
Yeah, it could be challenged. It could be hearsay evidence. But look, this has been recorded without the consent of the individual. It's a complex area. It's generally, shall I say this? Sometimes what can happen is in video evidence, if an interview has been, if a video recording has been made without the consent of somebody, then obviously that's their civil liberty being attacked. They didn't know about it at all, and that would be very difficult to then admit as admissible evidence in court, and that could be challenged under the hearsay rules. And again, that's a complex topic of evidence, etc. So it could be challenged within the UK system. We could make an application to the court and say, well, look, hold on, this was recorded without the consent of the client. But if it's part of a criminal investigation, a covert operation, etc., where the criminal agencies and the police or the Crown Prosecution, Customs and Excise are obviously recording and investigating a criminal offence, then clearly it will, unless the police have done something illegally, if they haven't got the right authority, except the Home Office haven't given them proper consent and so on, then we can challenge that. Otherwise, it's legally admissible.
Okay. All right. I think, so I think I've gone through most of the question I had for you for today. And so I wanted to thank you for joining us and sharing your knowledge and experience with our students and audience. So if there are any questions that are posted in the comment section and I receive them, and I'll send you an email if there are any questions and if they come up. And maybe we can ask you to join us in the future as well, and you can guide our students. So thank you very much for joining.
No, thank you very much, Mahmood, for joining. I hope those who were participating enjoyed the show or the lecture. And yes, more than welcome. Obviously, you can send those questions to me. And thank you very much.
All right. Have a great night.
I'm grateful and look to participate again in the future. If you need me, you know where I am.
All right. Thank you very much.
Thank you. Lovely speaking.
All right.
Thank you, everyone. Bye-bye.
All right. Bye-bye. Bye.